Salutations to all our future judges. In this video, we are going to see the Code of Civil Procedure 1908, Part 18, Sections 86 to 87A. If you have not seen the earlier part, that is Part 17, I am providing the link in the iCard. You can click that and watch Part 17. If you want to see the entire playlist, I am providing the link of the playlist in the description. You can click that and watch the entire playlist. Now let us move to section 86. Suits against foreign rulers, ambassadors and envoys. Generally, against a foreign state, a suit cannot be filed except with the consent of the central government, and that too, the consent should be given in writing. That is very, very important. And that should be given by the secretary to that government. These are the important points in this subsection 1. There is a proviso which we need to understand in this particular subsection. Imagine there is a foreign state, and that foreign state is putting some person as a tenant in a immovable property, and that person can sue without the consent. So if the foreign state is saying to me that you go and hold a property as a tenant, I am holding the property on behalf of that foreign state. In that case, I can sue without the consent. That is the important point. Let us move to subsection 2 under section 86. When a consent is given, it can be for a specified suit or for several specified suits or with respect to any class of suits. These are the important points which we need to understand. And in certain cases, the consent may specify that this consent is given only for a particular suit or case of any suit or class of suits. It needs to be mentioned. That is the second important point. And there are certain situations in which this consent will not be given. That is the important point. So when it will not be given, when it appears to the central government that the foreign state, point A, this foreign state is trying to sue a person who is desiring to file a case against it. For example, imagine I am a foreign state. You are planning to file a case against me. So to prevent that or to create an issue, I am trying to file a case against you. In that case, this consent cannot be given. Now let us move to the next point, which is point B. If this foreign state or through any other person is doing a trade within the local limits of the jurisdiction of the court, in that case also consent will not be given. And the next point is point C. This particular state, that is a foreign state, is in possession of a immovable property situated within those limits. So the point is, it should have an immovable property within the limits of that court. First point. And in that, the second point is that this particular property is going to get sued with reference to the money charged thereon. For example, I am a foreign state. I am holding an immovable property within the jurisdiction of that court, and I have to pay some money to someone. I have not paid the money, that is, the foreign state has not paid the money, and money has been charged on the property. In that case also, consent will not be given. Now let us move to the next point, which is point D. Imagine I am the foreign state. I am waiving off my privilege in this section. I am saying that no, I don't want all these privileges. I am waiving it off. It can be express or it can be implied. In both these situations, the consent will not be given. So there are 4 points or 4 situations under which a consent will not be given. So these 4 points can be asked in the preliminary examination. It's a very important section. Now let us move to subsection 3 under section 86. To put this subsection in a simple manner, if I want to execute a decree against the property of a foreign state, I need to get the consent of the central government in writing, and that too by a secretary to that government. 3 points: I should get the consent, I should get the consent in writing, and it should be given by the secretary to the government. If these three things happen, I can execute a decree against the foreign state. Now let us move to subsection 4. Now let us move to subsection 4. The preceding provisions, that is the subsection 1, 2 and 3, that shall apply to A, any ruler of a foreign state. First point. Now the second point is AA, any ambassador or envoy of a foreign state. That is the second point. The third is point B, any high commissioner of a commonwealth country. Generally, commonwealth country means the countries which were governed by the British or the colonies of British people. Generally, those countries together are called as commonwealth countries. Let us move to the next point, point C. Any such member of the staff of a foreign state. If he is the member of the staff of a foreign state, or the retinue of the ambassador, or envoy of a foreign state, or high commissioner of a commonwealth country. These classifications are determined by the general or special order of the central government. Now let us move to the next subsection, which is subsection 5. There are certain people who cannot be arrested under this civil procedure code. This is very, very important. Many times I have asked question from this particular subsection in preliminary examination. Any ruler of a foreign state cannot be arrested. First point. Second, any ambassador or envoy of a foreign state cannot be arrested. Now let us move to the third point, which is point C. Any high commissioner of a commonwealth country. Point D. Any such member of the staff of the foreign state or the staff or retinue of the ruler, ambassador or envoy of a foreign state or of the high commissioner of a commonwealth country as the central government may, by general or special order, specify in this behalf. So all these aspects, the central government by way of a special order will say, this particular high commissioner of a commonwealth country is exempted from arrest. They will put an order like this. So these people cannot be arrested under this particular code. Now let us move to subsection 6. Imagine a foreign state is making a request to the central government saying that please grant consent, I need to file a suit. So the central government, before refusing, so in case they are accepting, there is no problem. In case if they are going to refuse it in whole or in part, then an opportunity should be given to the foreign state to express its point of view, or it should be given an opportunity of being heard. So their side should also be heard. That is the simple point. Let us move to section 87. Style of foreign rulers as parties to suits. The ruler of a foreign state can sue. That is a simple point. And he can be sued also. He can file a case or someone can file a case against him. Then in that case, it should be done in the name of his state. For example, imagine there is a person A. He is the ruler in a state called as X. The name of the state is X and the ruler name is A. So in that case, we should file the case in the name of X, not in the name of A. That is the first point. In case, while giving the consent, the central government is saying, no, you should not file in the name of the state. You can file in the name of the agent of the ruler. There is an agent for ruler A called as B. In that case, you can file in the name of B or in any other name as specified by the central government. Let us move to section 87A, definitions of foreign state and rulers. Let us move to subsection 1 under section 87A. Particularly in this part, point A, foreign state generally means any state outside India. That is the first point. Second point is it should be recognized by the central government. So these 2 points are important in this point A. Let us move to the next point, point B. Ruler. Who is a ruler with respect to a foreign state? Let us take the same example. There is a foreign state by name X and there is a ruler by name A. If that ruler A is not recognized by the central government, in that case, that person cannot be considered as a ruler. Imagine there is a conflict between A and B. A is saying that I am the ruler, B is saying that he is the ruler. In this case, the central government is recognizing B instead of A. In that case, B becomes the ruler and not A. Now let us move to subsection 2 under section 87A. There are certain things which a court should take judicial notice. Here the word shall is used. The first thing, whether a state has been recognized or not recognized by the central government, the court should know this fact. The next fact, which is point B, is that whether a person has been recognized or not recognized by the central government to be the head of a state. So imagine that A is not recognized and B is recognized, but other countries recognize A. There is a confusion. So in that case, the court should know as to whom the central government has accepted as the head of the state. Let us consider there are three people, A, B and C. India is recognizing B. Pakistan is recognizing A. Bangladesh is recognizing the other person. In that case, the person who is recognized by India should be considered as the head of the state, and the court should know as to who has been recognized by the central government. That is the important point.
If you like the video, please do press the thumbs up button and leave your comments in the comment section. And do subscribe the channel and also share the channel with your friends. Let us join hands together and contribute for a learned society. Thank you.